Write a short note on New York Convention on Arbitration. The term Convention of Arbitration typically refers to the international treaties that establishes a common framework for the recognition and enforcement of arbitration agreements and awards. One of the most significant of this is the Convention on the Recognition and Enforcement of Foreign Arbitral Awards, also known as the New York Convention. Adopted in 1958 in New York, the convention requires courts of the contracting states to recognize and enforce international arbitration agreements and arbitral awards issued in other contracting states. This convention is widely regarded as a foundational element of international arbitration, facilitating trade and investment by providing a reliable and efficient means for resolving disputes without resorting to local courts. The New York Convention has been ratified by a large number of countries, making it one of the most important instruments in international trade law. It is managed by the United Nations Commission on International Trade Law, known as UNCITRAL, which plays a crucial role in modernizing the law of international trade. Under the New York Convention 1958, an award issued in a contracting state can generally be freely enforced in any other contracting state, only subject to certain limited defenses. These defenses are as under. A party to the arbitration agreement was under the law applicable to him under some incapacity. The arbitration agreement was not valid under its governing law. A party was not given proper notice of the appointment of the arbitrator or of the arbitration proceedings, or was otherwise unable to present its case. The award deals with an issue not contemplated by or not falling within the terms of the submission to arbitration, or contains matters beyond the scope of the arbitration, subject to the proviso that an award which contains decisions on such matters may be enforced to the extent that it contains decisions on matters submitted to arbitration which can be separated from those matters not so submitted. The composition of the arbitral authority was not in accordance with the agreement of the parties or with the law of the place where the hearing took place, the lex loci arbitrae. The award has not yet become binding upon the parties or has been set aside or suspended by a competent authority, either in the country where the arbitration took place or pursuant to the law of the arbitration agreement. The subject matter of the award was not capable of resolution by arbitration. Enforcement would be contrary to public policy. The New York Convention is not actually the only treaty dealing with cross-border enforcement of arbitration awards. The earlier Geneva Convention on the Execution of Foreign Arbitral Awards 1927 remains in force, but the success of the New York Convention means that the Geneva Convention is rarely utilized in practice.